I welcome you all to E-Chintan Shivir, a discussion on decoding WhatsApp new privacy policy, question of data protection and privacy. This discussion has been organized by APNA, Association for Parivartan of Nations. APNA is a non-profit, non-governmental organization run by a group of young individuals and other like-minded people who seek a positive change in society and are actively working towards this thing. The organization is inspired by principles of philanthropy and is acting upon its goal of creating a better and just society free from any discrimination based on gender, caste, creed, color, race, social and economic background. Currently, the organization is focused on campaigning and implementation of the Right to Education Act 2009 and ensuring its benefits to the underprivileged children. The efforts of the organization have contributed to the establishment of help desks in the private schools of Ranchi for grievance redressal of applicants and enrollment of students in the reserved category for underprivileged students at these schools. Our guest for today's discussion is Mr. Solomon Okedara. Mr. Okedara is a barrister and solicitor in the Supreme Court of Nigeria. He is also a managing partner at Solomon Okedara and Co., a firm of barristers and solicitors, and a co-founder of Digital Rights Lawyers Initiative, a not-for-profit NGO that focuses on promotion and protection of digital rights. He has an expertise in the field of human rights and digital rights, including data protection and privacy, digital identity, online expression, intellectual property, e-commerce, tech and corporate transactions, and artificial intelligence. Mr. Solomon currently serves as a legal researcher with Columbia University for the school's Global Freedom of Expression project. Thank you, sir, for joining us today. Before
Thank
we
you.
begin with our discussion, I would like to provide a brief introduction to the topic. The Data Protection Law of the European Union, General Data Protection Regulations, define personal data as any information relating to an identified or identifiable natural person, such as name, an identification number, location data, an online identifier, or to one or more factors specific to the physical, physiological, genetic, mental, economic, cultural, or social identity of the natural person. To ensure that this data remains private and protected, data protection laws are truly essential to prevent exploitation of personal data of individuals for benefit of big multinational corporations and political organizations. Now, let us begin with the discussion. So, my first question to you is, what do we understand by the very concept of privacy as a basic human right to be protected against arbitrary and unlawful interference as declared by the Article 12 of Universal Declaration of Human Rights and Article 17 of the International Covenant on Civil and Political Rights?
Barisha, thank you so much for having me and the invitation. Now, let me first start by saying the right to privacy in itself seeks to protect the individuality of a person. Now, and of course, when we're talking about the protection of this individuality, we are talking about the information that are personally identifiable, in themselves. Now, we're talking about your phone number, your email address, your Aadhaar number, your social security number, even your health records. Any information that can identify you as an individual. That is what privacy seeks to protect. Having said that, now in 2016, a court of appeal sitting in Lagos, Nigeria, delivered a judgment in a case called Abdul Karim and Lagos State Government. And the court stated that fundamental human rights are not ordinary rights, but they are rights that are elevated. And some of them, including privacy, have their origin in international conventions or treaties, just like the UDHR and ICCPR you mentioned. Now, and that they can only be restricted with due observance to the rule of law. Now, when you look at it, now you use the word basic. Oftentimes, people interchangeably use the word basic and fundamental for this right because they belong to a special class of human right. Now, because this right protects a person's individuality. Now, one thing I must say at this point is that no matter how popular you are, no matter how much of a public figure you are, either a president, a governor, or a prime minister, the fact remains that you have a part of you that must remain personal. And the right to privacy seeks to protect such power. And if you also look at it, in 2017, in the case of Justice K.S. Kusawami and Union of India, the Supreme Court of India made a landmark pronouncement when it declared and recognized right to privacy as a fundamental human right under Article 21 of the Indian Constitution. So I can tell you categorically that right to privacy is a basic and fundamental human right that must not be toyed with anyhow.
Very well, sir. As per recognized by the international treaties, the right to privacy has been adopted by many other countries following the international conventions. But, sir, I would like to ask you, what is the difference that you've seen between the approach of a developed and a developing country when it comes to the importance of privacy? Since the developing and the underdeveloped countries have many problems they need to overcome, such as poverty, illiteracy, provision of basic amenities, etc. So, do you think that they do not prioritize the issue of privacy infringement enough as compared to the developed countries?
Excellent. Thank you, Varisha. As much as developing countries and underdeveloped countries are still grappling with the challenges of poverty, lack of basic amenities, now over time they are beclouded from paying attention, due attention to the issue and concept of privacy. But because, to them, when there's still so much hunger in the land, privacy cannot be on the table. But that's actually misleading. That's actually erroneous. Because when you look at it, privacy goes to the root of our individuality, of our person. Now, we live in a world where identity theft is a reality. Now, the moment your data privacy is compromised, the next moment, all your licensing service may be gone in a few minutes. Sometimes you may be in the comfort of your room and you have been declared wanted by the police for a crime you know nothing about, all because somebody somewhere compromised your personal data. So when we look at it and we realize that these things happen around us almost every day, then developing countries, developed countries need to pay due attention to the concept of data privacy and must move fast as much as possible to legislate on data privacy and data protection.
Yes, sir. Thank you so much, sir, for answering that question. Sir, on that note, could you please elaborate the concepts of data privacy, data processing, and data protection? And also tell us how significant is data protection in this technological era where spreading information and misinformation is a piece of cake and it is being used as a weapon at the hands of big companies to exploit personal data of individuals to their advantage.
Thank you, Barisha. Generally, I must say this. For most people, particularly data protection enthusiasts, oftentimes people use the phrase data protection and data privacy interchangeably, as if they represent the same thing. That is not correct. Now, as much as they are closely interconnected, they are different. Now, data protection is a concept that focuses more on prevention of processing of unauthorized processing of personal data. That's it. While data privacy focuses more on the legal framework of protecting your data. That's what it's all about. So one side focuses on the technical structure of protecting your data, while the other one focuses more on the legal framework. Now, then talking about data processing. Data processing is the whole gamut of dealing with people's personal data. This entails data collection, analysis, transfer, categorization, every single activity involved in dealing with personal data is called data processing. Now, Now, consider the fact that we live in a technological era, the fear, the concern of data processing, particularly when they are unlawful. All of us can remember very, it's so fresh in the memory, the scandal of Cambridge Analytica, how it happened, how people's personal data were illegally mined for political purpose. Now, and I tell you that that reality, that scourge still lives in what till date. So you have all these big techs, they illegally mine our data, our metadata, and of course they use them for marketing purposes, they use them for political purposes. And I tell you, until and unless nations around the world regions put up comprehensive and formidable legal structure, those reality will still continue to be with us, and people's personal data will be exploited to the advantage of the big techs and of course and their cronies.
Thank you, sir, for mentioning the Cambridge Analytica case, which came as a bigger realization for the value of personal data and data protection. Because since then, many countries have made several statutory authorities in this regard, and some countries are still working on their laws. As per the data of United Nations Conference on Trade and Development, 66% countries have data protection laws, and 10% countries have drafted bills on the same, while still 19% countries have no legislation whatsoever, and there is no data for 5% countries. Sir, I would like to ask you, how would you describe this global progress on making data protection laws? And would you say that the statistics justify the current status of development of data privacy regulations?
Well, Barisha, I would say I would describe this progress as discouraging first. And discouraging because we live in a world where things change at the speed of light. Now, when you sleep today, you wake up to the next morning, you realize that what was protective of your data, of your status yesterday, is no longer protective of it today. Now, so these are the realities we live with. And when you look at it, I must tell you critically that legislation, regulation, they are actually meant to respond to our social realities. Now, a particular jurist made a particular quote some time ago, and he said the responsiveness of law to social reality is the life of law. So, if a law or the legal frameworks in the society cannot respond at the corresponding rate to the social reality of that society, then the laws are not working. So my point is that I realized and I have concluded that the rate you have, of course, the statistic you gave is very, very correct. But beyond that, the reality is that that situation is discouraging because we need to actually move as fast as we can. Let me give you an example. If you recall, the newly updated or modified WhatsApp privacy policy does not apply to European Union. And why? Because it's only a European Union right now that has a comprehensively protective legal framework. Now, but the point is that the rest of the world seems to be taking advantage of. Why? Because we're sleeping or something. So my point is that one, the progression rate is discouraging. Two, nations and regions around the world need to wake up and act fast to put structure in place to protect the personal data of their citizens and residents.
So thank you for mentioning the WhatsApp privacy policy issue here, because as it is understood for now, it is understood that the WhatsApp privacy policy is infringing upon the privacy of its users, such as their identity details, bank account credentials, and even text messages in certain cases. And as you mentioned, that because of the enforcement of GDPR in the European Union, the WhatsApp policy is not being updated over there. Sir, could you please walk us through in a bit more detail what are these features, particular of the new privacy policy by WhatsApp that are violative of the GDPR and that are stopping its enforcement there?
Thank you, Marisha. I think that seems to be the headache of most of us around the world, with the exception of the people in European Union right now. On the 4th of January 2021, the global community woke up to a shocking news from WhatsApp, and of course, giving us quick notice, as you may call it, or the moment you are given an option to abide by a condition, or you pull out, then of course that could be tantamount to a quick notice of sort. So now WhatsApp has asked us to consent to our data being shared with Facebook companies, not just only Facebook companies, because you remember Facebook has WhatsApp, has Instagram, and some other social media platforms. So now, and we were given 8th of February for compliance for those who still want to continue to use the platform. And of course, when you look at it, somebody who understands law and how law works, now the moment you are asked to do something within a particular timeline, and of course, if you fail to do it, you can actually be removed. It's as good as quit notice, as you can call it. Now, and of course, much recently, after there was so much uproar, so much criticism of such step, then the platform extended it to 15th of May 2021. Having said that, now in making some clarifications, WhatsApp has actually gone around the world to sponsor ads to make this explanation, because when after that thing came out, some of WhatsApp subscribers began to move to some competitors like Signal and Telegram. Now, of course, the WhatsApp is a business. It's not a not for profit entity. Now, they realized what that could be to them in terms of revenue. Now, having done that, the next thing was that they sponsored some ads to make clarifications about this. One of the clarification is that your messages, which are on the encrypted end-to-end encryption platform, will still remain the same. Meaning nobody could still access your messages. That's what they told us. Now, and of course, we are yet to get to that point where we can say, oh, my messages, I have proof that my messages were actually seen by third party. But beyond that, WhatsApp is telling us that our metadata will be shared by amongst Facebook companies, and of course can be used for advertisement purpose. Now, Barisha, that actually brings a whole lot of concern, because the truth is that Facebook as an entity has history of illegal mining of subscriber data. And of course, that was actually what happened in the case of Cambridge Analytica. And there were some other cases, perhaps didn't get to court and all of that. That issue of illegal mining of subscriber data was alleged against Facebook. Now, if you have stolen my neighbor's property in the past, and now you want me to trust you as a gatekeeper to my house, then you're giving me a whole lot of concern. Because right now, you're now saying my apartment will now be linked to your compound. Now, so that is what WhatsApp has actually told us. And so it's giving people a whole lot of concern. But of course, I must also state that even prior to that time, the Facebook and WhatsApp actually shared some information with WhatsApp, with Facebook. Now, your phone number, your location, and a few other information were being shared. The only thing is that your messages remain secure. They remain intact due to the end-to-end encryption. Now, having done this, many subscribers all over the world have a huge concern, and they are saying, come, I cannot trust someone who has actually been alleged, of illegal mining of data in the past. And that's what this reality is all about. And that's why there's opera. That is where there are filing of suits around the world, particularly in Asia and Africa.
Yes, sir. Thank you for putting it in such a great detail. In fact, today in the morning itself, when I woke up and first looked at my phone, the first WhatsApp status that displayed was disclaimer regarding all the sharing and all the updates that they've been making, which is a step of retraction of their steps, that they're realizing that people are understanding enough the importance of data protection in today's world, and it will not be as easy to fool the people as it was, say, a decade ago or in the past 10 years. So, like you just went back to the Cambridge Analytica case and what we saw in the 2016 US elections as well, where the state of election was manipulated and destined by Facebook in conspiracy with Cambridge Analytica and a political party, wherein they use the personal data of the users to mine it and target their ideology. So, with this new WhatsApp privacy policy enrolling, how bigger do you think it would, if came into action, would make an impact in the election process of other democracies as well around the globe?
Well, if I will take a position on your question, the first thing I would say is that as much as it currently remains unclear whether we are going to have a repeat of our 2016 episode, where Cambridge Analytica featured significantly. Like I said, this is a matter of trust. Now, the fact that you have actually breached my trust in the past makes me suspicious, of every move you make. Now, so the fact that Facebook has been alleged in a number of instances of unlawfully processing of personal data, I mean, particularly issues of illegal data mining, issues of sale of people's data, personal data, for political purposes. Now, it makes us worried. It makes us suspicious of anything we could get from them. And like we said right now, up to January 4th, when it came up with this quit slash compliance notice. Now, many persons around the world considered WhatsApp to be the safest platform to communicate. Now, because of the encryption, strictly put. Now, but right now, the moment I realized that my metadata can be shared, in fact, not can be, will be shared amongst Facebook companies, then these are companies that have allegations pending against them. These are companies that have judgments, of courts around the world against them on illegal dealing or processing of personal data. Then, of course, we cannot rule out a reoccurrence of 2016 episode. But having said that, another thing I want us to do is that beyond focusing on the big tech companies, now our government around the world have a huge responsibility to actually ensure that adequate legal framework are put in place. Because today, Barisha, just like we said, what actually exempted European Union from this updated or modified water policy is the comprehensive legal framework they have. Now, even from that policy itself, from the needs of that policy, it is stated on it, on the banner, that people in European Union are exempted. So they continue with the same conditions and terms of operation of the platform. So it is the rest of the world. When you look at it, and when you look at Asia, for example. I mean, Asia is a regional bloc that has inadequate, data protection frameworks. And come to Africa too. Even Nigeria today that has what is called Nigeria Data Protection Regulation. Now, some data controllers, including public data controllers, do not even reckon with the regulation because to them it's mere a regulation, not a law. So the point is that our governments have an urgent responsibility to ensure that there is an effective legal framework and enforcement policy.
Yes, sir. You mentioned all the data privacy like regulations that are there, but really cannot to be said to be a law. Instead, there are more of regulations. And similarly, on that path, is treading our own country, India, wherein the Personal Data Protection Bill 2019 is still pending in the Parliament, and there is a lot of debate stirred on that issue as well, because some say that where the ideal legislation is not suited for an Indian democracy, because although the bill has several provisions to limit the access of corporations to private data of the people, however, the bill falls short on restricting the government's access to the same. So, I would like to ask you, what is your analysis of this bill? And do you think that it would pose as a strong legislation to deal with the infringing policies proposed by giant corporations like WhatsApp and many more to come in the future?
Thank you, Barisha. In 2019, a 98 section Personal Data Protection Bill was introduced by the Minister of Electronics and Information Technology to the Indian Parliament for the purpose of enacting a comprehensive law to regulate personal data processing. And of course, I must state here that on the face of the bill looks very promising. Let me give you an example. If you look at the preamble to the preamble to the bill recognizes privacy as a fundamental human right. And of course, it goes further to say that it is necessary to protect personal data as an essential facet of informational privacy. Now, I will tell you that, of course, that actually benefited hugely from the pragmatism of the Indian Supreme Court. You know, in the case of Justice K.S. Putaswamy and Union of India, which I cited earlier, now the Supreme Court of India had a brilliant opportunity to set precedent by declaring right to privacy as a fundamental human right. Because prior to that time, right to privacy was never regarded as a fundamental human right. But in that case, the Supreme Court of India took that opportunity, it stepped into the occasion to declare it as a fundamental human right under Article 21 of the Indian Constitution. Now, of course, like I said, I believe that actually set the foundation for this bill, and of course, that reflects in the preamble. And of course, looking at the provisions of the bill itself, the bill, like I said, looks very promising. Aside the fact that if you place it side by side with the GDPR that applies in Europe, now you really will say that the data protection, personal data protection bill in India is not substantially wanting. Now, well, of course, there are issues, there are challenges. Let me actually mention one. Now, in GDPR, the owner of personal data is referred to as data subject. And of course, that's actually what applies in Nigeria, in Kenya, some other countries in Africa. But in India, of course, in that bill, it is referred to as data principal. But not just only an issue of nomenclature. Now, the substance of the bill, when it comes to right to rectification, right to be forgotten, right to data portability, most of the right a data subject has in Europe, then a data principal in India has them too. Now, of course, I must state this categorically that this section 5 of the Personal Data Protection Bill of India, it's actually a section that could be a shield for the people of India, or let me say for data principals in India, against this newly modified WhatsApp privacy policy. Because that section provides that personal data can only be used for the sole purpose that it was collected. Now, you can't collect people's personal data for their for their operation or on your social media platform. Then the next thing, then you convert it to marketing purpose. It cannot go. It cannot be allowed. But as of today, India does not have a data protection law, stricto sensu. The only thing that India has, of course, that you can explore is the Information Technology Act, the ITA. But even ITA, like I said, cannot, for example, if the issue of of illegal processing of data applies. ITA does not have a provision for compensation of a data to a data principal and all of that. So, and this is what the people of European Union foresaw and made them put together a well-protected and comprehensive legal framework. Now, so I believe strictly that substantially, personal data protection bill in India is promising, of course, with the exception of a few things you mentioned, of course, significantly, the fact that the government can exempt itself and its agency from compliance to the to the bill. Now, so the question is this: leadership, they say, is by example. So, if the person, the government who handed the law to us cannot comply, then how well does it think the citizen should comply? How well does it think the big techs that have the money will not circumvent the law? So that gives a whole lot of concern. And I think if the Indian Parliament could take care of that, well, there may not be so much to be worried about. However, I also need to quickly add the fact that there are about 400 million subscribers, WhatsApp subscribers in India, and that's a whole lot. Now, if nothing is urgently done by the Indian Parliament to survey the situation, then so many persons' data may actually be up for sale, and of course, there may be so much to worry about.
Thank you so much, sir, for explaining it in such an elaborate manner. And as you mentioned, K.S. Puttaswamy judgment, which was in fact against the initiative of government of Aadhaar, which is the UIDAI. Even in that case, the party that was the judiciary was trying to prevent infringement of people's personal data against was the government. And this bill itself does not shield the people from the government, which has been set in the laws through years of legislation and judicial precedents. Sir, as you mentioned very appreciatively about the guidelines of data protection that are given under General Data Protection Regulations of the European Union. So do you think that this could be a model for all other upcoming legislations on data protection, despite the fact that every country is different and has a different composition and therefore needs a legislation tailored to suit its social and political standing? So what do you think in that case would be an ideal data protection policy which the countries should follow?
I've been GDPR as a model of regulation on data protection around the world. Maybe having it as a model, it's a good thing. And let me say that it could be an excellent foundation. I use the word foundation deliberately. Now, because you see, when you consider something to be a model, now oftentimes you are considered to actually produce another version of it. Now, but then the good thing is that all of us around the world have different peculiarities and particularities in our affairs, in our socio-economic economic realities, and other matters. So the fact that as much as the GDPR appears very comprehensive does not mean that every society, every state should take it and reproduce it the same way it is found in Europe. Now, like I said, it's going to be an excellent foundation for most countries around the world. And trust me, I can tell you that most countries around the world actually used the GDPR as a foundation to build or to model their legislation or regulation on data protection. But beyond that, whatever regulation or legislation you have on data protection must also reflect the peculiarity in your society. It must also reflect the particularity of your economy, of your structure, and all of that. So when it does that, then we will be fixed in a box that applies to a European but does not apply to an Indian, does not apply to a Kenyan, does not apply to a Nigerian. So, like I said, GDPR is an excellent foundation, but nations must learn to build on it and adjust and consider it how it suits their peculiarities.
Thank you, sir, for guiding us through the how we should not exactly adopt it as a model, but as a concept and a foundation. So, throughout this discussion, if do you think if the concept of data protection and privacy is important as we have put it? So, are there roles reserved for the judiciary? Since in the recent cases of serious privacy infringements, one of them being the WhatsApp privacy cell, petitions are being filed in the courts. And in the past also, we have seen, as you mentioned, the K.S. Puttaswamy case as well, wherein the courts have played an important role in, making that particular law for data privacy infringement. So, in such cases, at this point of time, what would be the role of courts?
Thank you, Varisha. I must say at this stage, particularly because I'm a practitioner, I'm an advocate. I mean, I go to court to walk around data protection, to challenge infringement of data protection and privacy in Nigeria. Now, and of course, I'm involved in analysis, in nations around the world. I can tell you, just sitting down here, about 10 cases I've worked on data protection and privacy in India and in some other countries around the world. But then clearly I must say that the judges have very important roles to play a good number of times. Now, because their roles, as you know, are the first role they have is to interpret legislation. Now, when disputes are brought before them, they interpret them. Now, as much as we all know that judges don't have legislative powers, what they have are interpretative powers. Now, that powers can be used very well, can be used productively, can be used to even cure whatever defect we have in the existing legal framework. Let me give you an example. In Nigeria, my organization, Digital Lawyers Initiative, we went to court on violation of data, on violation of personal data by an agency of the government. Now, when the court was delivering judgment in that case, then the court said that the issue of data protection is an extension of privacy. But having said that, the suits that were brought before the court cannot be brought as a fundamental human right. And that gave us a whole lot of concern because that in itself, Barisha, was a clear contradiction. Because under the Nigerian law, I mean, the Nigerian constitution, just like it applies in Article 21 of the Indian Constitution, privacy, right to privacy is a fundamental human right. So when you have a concern of its infraction, when you go to court, you challenge it as a fundamental human right. Now, and this court in its judgment stated that data protection is an extension of privacy. However, it cannot be challenged as fundamental human right. So for me, I think it was a matter of approbating and reprobating at the same time. And it's because a good number of times, our judges are not actually well updated themselves, their knowledge on the subject of data protection. Many of them consider it to be a novel thing, and they are scared of getting immersed in such novelty. But the good thing is that I think that even if data protection is entirely new, it gives the judges opportunity to make law by interpretative role. That's it. That's the template the Lord Denny, the late Pastor Rose, gave us. Now, judges may not legislate, but they can make laws by stretching the law, by telling us, by giving it such an expansive interpretation that will advance the society. Now, that's number one. Then, number two, I believe that, for example, Nigeria as of today doesn't have a comprehensive data protection law. What we have, like I said, is a regulation which was issued subject or pursuant to an existing act, national law. Now, so a good number of times, data controllers don't regard that regulation. Now, in some other situation, the court sees it as a mere regulation. Now, for Section 37 of the Nigerian Constitution provides for protection of right to privacy. So I believe that if the court can see its role in interpretative capacity as a lawmaking one, or even to interpret to the point that if data protection can be an extension of privacy, then a citizen can come under Section 37, which provides for right to privacy and challenge an issue of data protection. And of course, like we saw in the case of Justice Putaswamy, now that laid a brilliant foundation for the Indian community and Indian nation at large. And for me, I think judges should do more of being proactive, of being willing to protect people's personal data, even without a comprehensive data regulation or legislation as it may be.
Thank you so much, sir, for sharing your experience with us. And from what I can understand from that is that it is time that we go beyond the books, beyond the the ready-made provisions of law that we have, into the field of more of interpretation to build up a futuristic legal stance to protect our citizens and the countries from these data infringement and other futuristic problems of law. So my last question to you is that what is your greatest fear about data protection and privacy today, given the scenario of the past decade with numerous incidences of data manipulation and data theft, whether it be WikiLeaks or whether it be Cambridge Analytica? So what would you say is that you fear the most?
Well, Barisha, my greatest fear would be that someday I sleep and I wake up and I realize that our governments have left issue of data protection in the hands of the big techs. Now that day, then maybe I would rather say that say something in the words of a late writer, a late revered writer from Africa. His name is Chinua Achebe. He wrote a book titled Things Fall Apart. Now, when that day comes, that India government leaves the issue of data protection in the hands of big tech, whether deliberately or by negligence. When the government of America, when the government of the United Kingdom, when the government of Nigeria does that, then things will naturally fall apart. Then by then, I can tell you categorically that we may no longer even be citizens of our nations anymore. They will as well be citizens of the tech companies. Now, that is the position, because big techs, we have seen them, that they don't have any interest other than profit. They want to make money. And so what they keep doing day in, day out is to actually make money from our data, from our privacy. So, and the moment our government cannot actually stand to the occasion, cannot set up the required comprehensive legal framework, enforcement structure to protect us, then we could as well stop carrying about Indian passports, Nigerian passports, and carry about Facebook passports, Twitter passports, and what have you. So my greatest fear is to realize that someday our governments are no longer responsible and responsive to comprehensively protect our data.
Thank you, sir, for putting it so well. And I very much agree with you because, as they say, technology is a good servant but a bad master. And so we are treading on that path. And it was such an it was such an informative discussion with you. But we will wrap up this session over here. And thank you so much, Solomon sir, for being with us and enlightening our viewers with your knowledge and experience about the issue of privacy and data protection, and explaining the ramifications of the arbitrary privacy policies of the IT companies and other organizations, and highlighting the necessity of data protection laws to safeguard the rights of individuals in today's time. Thank you so much, sir. Thank you.
Thank you so much, Barisha. It's my pleasure. And I want to say congratulations to your entire team. I look forward to future engagement and more interaction in the near future. Thank you for having me.